Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On November 2nd, the court heard arguments in Houston Community College Sys v. Wilson, a case which concerned whether the First Amendment restricts the authority of an elected body to issue a censure resolution in response to a member's speech. Joining today to discuss oral argument is Jordan Pratt, Senior Counsel at the First Liberty Institute.
First Amendment jurisprudence is full of dissidents and rabble-rousers. Houston Community College System against Wilson is no different, and it presents a very interesting question that springs from a very interesting fact pattern. First, I'll cover the case's background and procedural history. Then, I'll summarize the parties' positions, give a quick take on the oral argument, and conclude with a few more thoughts. David Wilson was an elected trustee on the board of the Houston Community College System. It's safe to say that he and his colleagues didn't get along too well. During his tenure as trustee, Wilson sued HCC several times. The board accused him of leaking confidential information, and Wilson savagely criticized the board and its members. Generally, he accused them of pay-to-play corruption. There may have been something to Wilson's crusade. The longest-serving trustee ended up getting convicted on federal bribery charges. In any event, a boiling point came in 2017 when HCC decided to fund an overseas campus in Qatar. The project predictably involved some extravagant foreign travel. Wilson sent out robocalls to constituents. He hired a private investigator to snoop around. He accused his colleagues of crimes on his website, and he filed another lawsuit. In January 2018, the board adopted a resolution that censured Wilson. It recited his conduct, said that it deserved discipline, and issued its censure. Under the censure, Wilson was ineligible to be an officer for a year. He couldn't receive travel reimbursements, and he would need full board approval to access certain funds. It also ordered him to cease and desist his behavior on pain of further discipline. Wilson responded by adding a First Amendment retaliation claim to one of his pending lawsuits. The case was removed to federal district court, which dismissed the suit. The Fifth Circuit reversed, holding that Wilson had stated a First Amendment claim against the censure. But the court agreed with HCC that the added restrictions beyond the censure did not violate the First Amendment. The Fifth Circuit narrowly denied en banc review, with 8 judges dissenting. Judge Jones warned in her dissent that the panel's decision would stifle legislative debate and government speech, and it would thrust federal courts into political disputes without manageable legal standards. Judge Ho also dissented. He emphasized that the First Amendment protects the freedom of speech, not a freedom from responsive government speech. And he stressed that political leaders should withstand criticism. HCC then petitioned for certiorari, and the Supreme Court granted review. So, as to HCC's arguments, it first contends that there is no First Amendment claim for retaliatory censure. HCC notes that typically First Amendment retaliation claims involve coercive government conduct like arrest, prosecution, or termination of employment. And HCC notes that precedent distinguishes between government coercion and government speech. So in short, government speech doesn't chill speech unless it threatens some sort of coercive retaliation. HCC also argues that recognizing a First Amendment claim here would be inconsistent with history and tradition. It first points to English practice and notes that legislative discipline has a long tradition dating back to at least the mid-1700s. Methods of discipline even included expulsion and incarceration, not even to say censure. HCC also notes that discipline was aimed at members' extra legislative speech. The most famous example was when Parliament expelled John Wilkes in 1764 because he had published a pamphlet that was critical of a peace treaty with France. Wilkes was repeatedly reelected, but Parliament refused to seat him until 1774, so 10 years later. There was a public outcry, but HCC notes that the outcry was because of the refusal to seat him, not because of the initial expulsion. HCC also points to colonial, federal, and state practice. The colonies adopted the English Parliament's disciplinary practices, and the Philadelphia Constitutional Convention spent little time debating Article 1, Section 5, which authorizes Congress to punish its members, even by expulsion. The debate focused not on whether to confer an expulsion power, but rather on how to limit the expulsion power by requiring a 2/3 vote. And of course, Congress has always understood that the greater power of expulsion includes the lesser power of censure. The Senate first issued a censure in 1811 and the House in 1832. Likewise, state legislatures have long exercised their disciplinary power to censure members. And that practice carried over also to local government bodies. So like their federal and state counterparts, they have consistently disciplined members through censure, and in many cases have issued censures for members' extra legislative speech. And HCC provides numerous examples in its briefing and in its appendix. HCC next argues that recognizing a First Amendment claim here would suppress responsive government speech and would undercut First Amendment values. It contends that legislative censure is core government speech. It notes that government bodies generally have the right to speak for themselves and even to favor one viewpoint over another. That's, of course, something they could never do when regulating private speech. Here, HCC expressed its disapproval of Wilson's lack of civility and respect, and HCC contends that that's a core example of government speech. HCC also argues that speech conflicts between elected bodies and their members are for the voters to resolve and not for the courts to resolve. Essentially, what we have here is a public debate between the board and one of its members, and HCC argues that stifling one side of that debate would cut against First Amendment values, and that it's the democratic process, not the courts, that provides a check against undesirable government speech. And HCC, of course, also notes that criticism comes with the job of being an elected official, and they're supposed to have thick skins. So Wilson responds with a few points. First, he argues that the First Amendment protects elected officials from formal punishments for their extra legislative speech. And Wilson tries to cast this as almost sort of an agreement, at least in framing with HCC, that that punishment for speech is not permissible under the First Amendment. And Wilson first points to Bond against Floyd, which was a 1966 decision. In Bond, the Georgia House excluded a member in response to his public opposition to the Vietnam War, and the Supreme Court unanimously ruled for the member, holding that he couldn't be excluded for his protected speech. Now, Wilson concedes that the court's other cases allow discipline for legislative speech. He argues that the court should treat extra legislative speech differently, and that that's what the court did in Bond. In short, he draws a bright line between legislative speech, which can be punished, and extra legislative speech, which can't. Wilson argues that he has a claim here. He argues that formal censures issued as an exercise of disciplinary powers are always punitive and therefore barred by the First Amendment. He first turns to founding era history. He agrees with HCC that censure was commonly used in England and in the colonies, but he draws a different inference. His inference is that the framers rejected that practice, at least insofar as it targeted extra legislative speech. He seizes on the John Wilkes example, just like HCC does, but he argues that it was Wilkes's initial expulsion and not just Parliament's refusal to seat him after re-election that the framers found problematic. Wilson also points to the Whiskey Rebellion. After the Whiskey Rebellion, Washington had asked Congress to censure the insurrectionists, and James Madison opposed that request. Madison's position carried the day, with some congressmen specifically arguing that a censure would chill free speech. Wilson next turns to modern practice. He contends that the Supreme Court has twice held that a censure can violate the First Amendment, first in a 1990 case called Peel, and second in a 1994 case called Ibanez. He also notes that government bodies themselves recognize censures as a form of punishment because they often establish trial-like procedures for issuing a censure. But even if a bare censure were not punitive, Wilson contends that he did not receive a bare censure, but instead it came with additional penalties. Wilson next argues that the censure was not shielded by the government speech doctrine. He argues that the censure wasn't just government speech because it was accompanied by a punishment, and it was that punishment, he contends, that violated the First Amendment. He also notes that many government bodies, like the board in this case, distinguish between position statements, which are government speech, and censures, which are punishments. Finally, Wilson argues that HCC is wrong about the censure's impact on First Amendment values. He contends that these kinds of censures stifle political debate by chilling the free flow of ideas, and that silencing members doesn't foster debate, it stunts it. He also observes that censures are rare. The House has issued only 23 in its entire history, and the Senate only 9. Only 21 state legislatures have ever censured a member. So, according to Wilson, there can't be a robust tradition of censures for protected speech because there isn't a robust tradition of censures. Wilson next observes that at the local level, censures for extra legislative speech are extremely rare, and 21 municipal bodies expressly prohibit those sorts of censures. So HCC replies on a few points. First, it notes that this case, as a procedural matter, involves only censure, and that's because the Fifth Circuit's decision held that the additional measures taken against Wilson did not violate the First Amendment, and Wilson did not cross-petition for certiorari on that question. So that question is not before the court. But even if that question were before the court, none of them rises to the level of a punishment that would chill the speech of an ordinary politician. A censure isn't coercive like a fine or an expulsion. HCC next turns to the Bond case and observes that Bond dealt with a complete exclusion of an elected representative based on his pre-election speech. And that's, of course, several steps far removed from this case. HCC next argues that Wilson's historical contentions are just wrong. HCC says that the distinction between legislative and extra legislative speech that Wilson is trying to draw sounds in the speech and debate clause. And that clause, of course, is a separation of powers provision. It doesn't limit Congress's power to discipline its members. Instead, the clause limits the power of the executive and of the courts. And, of course, the Constitution elsewhere expressly empowers Congress to determine its rules and to punish members, including through expulsion. And the Constitution does not anywhere expressly limit the censure power. HCC reiterates that censures haven't been limited to speech and conduct that occurs within the legislative sphere. Especially at the local level, there have been numerous censures in response to extra legislative speech. And furthermore, HCC argues that there's no logical reason why the First Amendment analysis should turn on where the censored speech occurs. As for the Wilkes incident, HCC contends that it supports the college's position because the framers didn't respond to it with any limit on Congress's disciplinary power in Article 1, Section 5. All that the framers did was to spell out the qualifications for membership in each house and to require a supermajority for expulsion. As for the Whiskey Rebellion, that episode dealt with something very different, which was a proposed censure of private citizens. But in any event, there's no reason to think that Congress's rejection of the censure turned on its interpretation of the First Amendment. HCC next accuses Wilson of putting form over substance. Under Wilson's position, the First Amendment analysis turns on whether something is labeled a censure or a position statement, on whether it tells a member to stop his speech, and on which bylaw the resolution cites. Those, according to HCC, are all just artificial distinctions. Now, HCC acknowledges that censures are a punishment in at least some sense, but the question, it says, is whether they are sufficiently punitive to implicate the First Amendment. HCC next turns to the Supreme Court cases that Wilson relies on, Ibanez and Peel, and it notes that those didn't involve just simple censures. They involved direct prohibitions that were enforced through censures. And the First Amendment problem, according to HCC in those cases, was the prohibition, not the censure itself. Finally, HCC reiterated that allowing these kinds of claims would entangle courts in political disputes that are best left to the voters and would undermine First Amendment values by inhibiting government counterspeech. As for the oral argument, which occurred on November 2nd, I hesitate to make any confident predictions, but I think it's safe to say that Wilson faced an uphill battle with the justices. One theme that HCC effectively developed at oral argument was the formalistic nature of the rule that Wilson proposes. Essentially, that if Wilson gets his way, the First Amendment analysis will turn on the label that a government body gives its reprimand and on whether the censored speech is legislative or extra-legislative. Now, during the argument, Wilson valiantly tried to turn that vice into a virtue. He framed his proposal as a bright-line rule, but the justices didn't seem to be buying it. The Chief Justice called the distinction artificial and pointed out that a board could adopt a resolution that essentially says, we would censure you if not for that crazy Supreme Court decision in Houston Community College System, which said that we can't do that, so here's a resolution expressing our disapproval instead. Justice Barrett also seemed skeptical that it should make a First Amendment difference whether the speech occurred inside or outside a government proceeding. She offered an example of a legislator using racial slurs during a floor debate versus using those slurs at a press conference immediately after the debate. Justice Kagan also seemed to share Justice Barrett's skepticism of that distinction. On the other hand, it was clear that several justices were considering a narrow ruling that doesn't address other stronger forms of legislative discipline, like expulsion. Justices Thomas and Sotomayor both asked HCC what the limits are on a government body's disciplinary power, and Justice Kavanaugh suggested that harsher forms of discipline might pose harder questions that the court should hesitate to address now. The United States argued as an amicus supporting HCC. The Assistant to the Solicitor General agreed with HCC that the court need only decide whether a censure triggers a retaliation claim, but he also argued that even if the court considers the additional restrictions, they fit comfortably within the punishments that legislatures historically have imposed on their members, and the First Amendment didn't abrogate that tradition. So I'll conclude with a few thoughts on the significance of this case. On the one hand, this case has some pretty broad implications. Just think about how many deliberative government bodies there are across the country. Not just Congress and the state legislatures, but the tens of thousands of state and local boards. This case is a great illustration. It comes out of a community college system's board of trustees. So there are a lot of public bodies to which the court's ruling will apply. On the other hand, the court's decision is unlikely to impact First Amendment retaliation jurisprudence more broadly. Censures by government bodies are unique. They're not really analogous to other situations where we see retaliation claims, like employment, arrest, and prosecution. So the court's ruling probably won't make any waves in other areas of First Amendment doctrine. One thing that this case might add more generally to First Amendment doctrine is the role of history and tradition in interpreting the Free Speech Clause. The argument began with a colloquy between Justice Thomas and HCC about whether a ruling should be based on history or instead on the government speech doctrine. HCC offered that either would provide a sufficient basis for reversal. The Chief Justice seemed a bit skeptical of the historical approach, given that much of the history predates the First Amendment, and the framers didn't always like that history. But Justice Thomas circled back to the topic with the Assistant to the Solicitor General, who said that the United States favors the historical approach because it's narrower and it makes the path to reversal so clear. Of course, originalism, at least the conscious kind, hasn't appeared very often in the court's free speech jurisprudence, but this case does offer the court a pretty clean vehicle to make history a central feature of its analysis. Depending on how the opinion gets written, that might end up being its most significant jurisprudential contribution. I'd like to thank the Federalist Society and its audience for hosting me, and like many of you, I'll look forward to reading the court's forthcoming decision in this case.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.